Hello and welcome to Topic 9, and this is the first lecture in Topic 9, and this topic is dedicated to taking a look at sexual intimidation. So what are you going to be learning about in this lecture? Well, first we're going to compare the regulation of sexuality to sexual intimidation. And so the last topic was dedicated to looking at regulating sexuality, pornography, and prostitution in particular. And this topic is dedicated to sexual intimidation. And so we're kind of going to compare and contrast the differences between regulating sexuality and sexual intimidation. And then we're going to set the stage for the next lecture. And so the next lecture is going to focus in detail on sexual assault and the way that policy has changed over time, and also sexual harassment. And so we're going to just define what we mean when we say the word sexual assault and sexual harassment, define those terms, and then we're going to talk about the difference between sexual assault and sexual harassment. So let's go ahead and get started. Now, in the last chapter, in topic 8, we examined regulation of sexuality. And so we were looking at the regulations, public policies, laws that are related to the conduct and depictions associated with sexual feelings and desires. And so we were learning about prostitution and pornography last week. This week, we're going to be taking a look at sexual conduct and sexuality, and how these sexual conduct and sexuality are used to threaten, control, terrorize, or coerce a person. And so, this chapter is dedicated to sexual intimidation. In this chapter, you're going to be learning about rape and sexual assault on colleges and university campuses, sexual harassment, and intimate partner violence. And so in lecture, we're going to be setting the first lecture is going to be taking a look at sort of the big picture regarding sexual assault and sexual harassment and approaches that feminism takes to those topics. And then in the second lecture, we're going to dig in and we're going to look specifically at sexual assault. And so it will be left to you to read the textbook, and we're going to be talking somewhat about sexual harassment in this lecture, but make sure that you dig in more deeply as it relates to sexual harassment and intimate partner violence in terms of reading that in the textbook, okay? Now, as we saw in the last chapter, the regulation of sexuality is regarded mostly as a public problem. That prostitution and pornography are regarded as public problems because they are, for the most part, seen as sort of public transactions. And so with prostitutions, you have individuals who are basically selling a commodity for all practical purposes, and they're looking for a buyer. And that, what they're selling is based on, sexual feelings and desires, but it's brought out into the public. And there are public harms that, come with from prostitution, at least as how it was regarded in what we were reading about in the chapter, in terms of the way we thought about prostitution and the way that was regarded as a public harm that was in need of some sort of policy solution. And so, with prostitution, it could be seen as a public harm because if it's unregulated, then it could transmit disease. Also, brothels, houses of prostitution, that they can bring about criminal elements around outside of it, vagrancy, drug use, maybe violence if people aren't paying. So it's seen as causing harm to the public. And pornography is regarded as the same. I mean, pornography is this depiction of images that arouse sexual desire, but that's not something that you may look at it in the privacy of your own home, but it enters into the public marketplace of ideas, movies, magazines, etc. And so since it's in the public and has the potential for being publicly distributed as a public sort of transaction within the marketplace of ideas, that it could potentially cause harm. People see it. It could influence the way they think about sex. It could, obviously the radical feminist point of view is that it sort of, saw women as depicted as sexual objects, that sometimes pornography is violence. and so is violent, and so causes harm to the public. Also, both prostitutes and those who are engaging in pornography, they might be seen as victims as well. And so, it's seen as harm that is then ripe for government intervention. And so regulating sexuality seems like a very legitimate exercise of government power. Why? Because government is there to prevent harm, right? That when harm is taking place within a society, one of the roles of government is to protect people from that harm. And so the way we think about prostitution and pornography, at least historically and even into the modern era, are basically seen as really public problems that need public solutions. Now, when it comes to sexual intimidation, sexual intimidation is seen mostly as a private problem for most of United States history. And that probably comes to you as quite a surprise, since sexual assault and sexual harassment seem to be clearly an issue of public concern. But until the 1960s, that was not the case. Well, why? Well, it was a reflection of, assumptions regarding gender norms, and also the way those assumptions were actually embedded within public policy. So in the case of daughters or wives who were sexually assaulted, it really wasn't the responsibility for the government to step in and do something about those sorts of harms. Rather, it was the responsibility of the father, in the case of a daughter being harmed, or a husband being harmed, in order to protect their wives. And that's a reflection that we learned about in our chapter on marriage policy. That's a reflection of coverture. And so, as you remember, that coverture is when you get married, women lose their legal rights. They are basically become, for all practical purposes, property of their husband. And so that, since the wife is the property of the husband, if somebody from the outside is trying to sexually assault your wife, right, then it's the husband's responsibility to protect their wife from that harm. Same with the daughter. Father was the head of the household. Women, before they were married, were still seen as property of their dads, and then they transfer that property over to when they would get married. And so it was the personal responsibility of the father to protect their daughters from that sort of assault. And in the case of assault within a marriage, it wasn't viewed as a harm. Once again, coverture, because women, as being property of husbands, and I guess the same would apply to daughters as well, although that would have been a real stray from sort of the norms of the time period. Same with assaulting your wife, but there weren't public laws prohibiting it. In the case of assault within a marriage, it wasn't really considered a harm because of coverture, and so there was no need for this to be seen as a public problem. And in the case of assaults on other women, it wasn't seen as a true harm, right? That, for one, as we're going to be learning about when we talk in more detail about changes in public policy, that the only kind of rape is forcible rape, because only women who are pure and filled with faith or chastity, they would fight to the death in order to prevent themselves from being sexually assaulted. And if you didn't fight to the death, then you kind of wanted it, right? And so it was sort of seen as, in the case of other assaults, as sort of like, it wasn't really a harm to the woman, but it was more seen as, the natural lust of men gone too far. And for those of you who maybe watch Succession on HBO, that another attitude about sexual assault and intimidation is that, no real person was involved, NRPI. And that becomes sort of this point in Succession where you have this company that looks the other way on sexual assaults. And they said, you didn't really have to pay attention to that because the people who were assaulted were just workers. They weren't people of any value. And that was the case, in terms of thinking about sexual assault prior to the 1960s. People who worked in homes, servants assaulted, no real person involved. When sexual intimidation did become a public matter, it was that the government would get involved only in the most extreme instances. In instances of true rape, which would be forcible rape. And at that point, then the government had a responsibility to step in. But all other forms of sexual intimidation were private matters. Now, that approach to thinking about sexual intimidation changes enormously and dramatically in the 1960s, and in large part due to feminist activism, which we're going to talk about more when we get to the next lecture. Now, where does feminism weigh in when it comes to the regulation of sexuality and the sexual intimidation? Well, as we know from last week, there are significant disagreements within feminism regarding the regulation of sexuality. And as we know, that stems from the significant disagreements and differences between radical feminists and liberal feminists. As we learned last week, that radical feminists consider pornography and prostitution as harmful, that they reinforce sexism and patriarchy, and that it's a harm that needs to be addressed. And so radical feminists are much more likely to, see depictions of sexuality as reinforcing women as subordinate, and that it's a product of patriarchy, and that it can bring about real harms in terms of victimization with prostitution, with sex trafficking, and also the harms that come with people who are involved in the production of pornography. So radical feminists see the regulation of sexuality as something that needs to take place. They view it as a public problem. Liberal feminists take a very different approach. They don't regard the regulation of sexuality as fundamentally harmful. That's not to say that liberal feminists don't, liberal feminists don't support sex trafficking. Liberal feminists don't support child pornography. But when you have consenting adults involved in the selling of sexual conduct and or behavior or sexual acts, and consenting adults involved in the production of pornography, they're fine with it. They view it as an expression of liberty and autonomy. So when it comes to the topic of regulation of sexuality, big differences within feminism. Now, when it comes to feminism and sexual intimidation, there are really no fundamental disagreements within feminism regarding sexual intimidation. All feminists, for the most part, regard sexual intimidation as having to do with power, not sexual desire, so that when the action of sexual assault, rape, the action of sexual harassment, intimate partner violence, that those are not expressions of sexual desire, but they are about one person trying to have power over another person. And feminism agrees on that. Feminists also agree that sexual intimidation needs to be front and center on the public agenda. All feminists regard sexual intimidation as a public problem that needs a public policy solution. And in fact, feminists were on the forefront of getting sexual intimidation, sexual assault, and sexual harassment on the public agenda. As feminists rose in power in the 1960s and 70s, that they raised consciousness about the prevalence of sexual assault and sexual intimidation and sexual harassment within our society. They opened, they had groups where women and men could come and talk about, but primarily women come and talk about sexual intimidation. Rape hotlines were started in that time period in 1960s and 70s. And so feminists were on the forefront of identifying that problem and getting it on the public agenda and changing sexual assault and sexual harassment laws. Now, in all ideologies, there's going to be some disagreement, and we know that feminism is about different types of feminism. And so your textbook does talk about that there are some differences in terms of how to approach sexual intimidation that are expressed within the difference between equality feminists and dominance feminists. And so make sure you read about these in your textbook. Equality of feminists, EF, their concern is that they worry that if the government gets too involved in addressing sexual harassment and sexual assault, not that they get too involved, but it's almost like women can't that they don't have autonomy, that they're sort of victims. And equality feminists are concerned about that. They say, look, women are strong, men are strong, that they're capable of taking care of themselves. And so if they are in an unhealthy relationship, if they're in a work environment that is filled with sexual harassment, that they know what to do. They're strong, they're powerful, and they can, take on the system. They can get out of the harmful relationship or marriage. And don't just treat those who are victims of sexual intimidation and sexual assault and sexual harassment as victims, okay? And so, they sort of, want to put an emphasis on that people who are subject to sexual intimidation are powerful, they have autonomy, and they don't always need the state to treat them like children or like, be really paternalistic in terms of protecting them. Dominance feminists, take sort of a different approach. They basically say that a lot of the institutions that produce sexual intimidation are the products of sexism. And so the institutions of higher ed, the institutions, workplace institutions, and also the institution of marriage. And when you look at the institution of the criminal justice system, basically say that those are institutions that are a product many times of sexism. And so that people who are victims of sexual harassment and sexual assault need help taking on these really powerful institutions in order to get justice. So not a big difference. I mean, there's differences, but still united in the notion and the commitment to sexual intimidation being seen as a public problem that needs to be addressed. Okay, so now let's turn our sights to defining some terms. And so let's talk about what the difference is between sexual assault and sexual harassment. So sexual assault is, it's a crime, and it's defined as intentional sexual contact without consent. So if somebody touches somebody else in a sexual manner without their consent, then they've engaged in sexual assault. It's also not just a sexual contact without consent, but it could also be intentional, forcible, or coerced sexual contact. And all people can be victims or perpetrators of sexual assault. Oftentimes we think about sexual assault that the perpetrator is male and that the victim is female, but that's not the case. Anybody who engages in sexual contact without consent or any sort of forcible sexual contact has committed a crime. Examples of sexual assault would be, non-consensual kissing, non-consensual sexual touching or grabbing. All of those would be defined as sexual assault. Flashing, exposing your genitals to somebody without their consent, that would be considered sexual assault. And non-consensual sexual intercourse or any kind of non-consensual sexual penetration would be considered sexual assault. That's not an exhaustive list, but those are just some examples of sexual assault. So what is sexual harassment? Well, sexual harassment is sexual intimidation or pressure that usually takes place in a workplace or an educational environment. That doesn't mean that sexual harassment couldn't take place in other venues. It can, but usually sexual harassment takes place in institutions like a workplace or an educational facility. And the key there is harassment. So, harassment is trying to intimidate or pressure somebody. Sexual harassment is harassing someone on the basis of sex. And it's oftentimes considered a form of sexual discrimination because if you work or are going to a school in an environment where there's a lot of sexual intimidation, or coercion, or pressure, that is a discriminatory work environment. You are being discriminated on the basis of sex, and that's prohibited by civil rights legislation. So it's considered a form of sexual discrimination because it creates a hostile or a coercive work or educational environment. Some examples of sexual harassment are unwanted sexual advances. So anybody who's like comes to to you and is like, hey, you want to go on a date, or woo, like, oh, like you look sexy today, and that would be not necessarily a form of illegal sexual harassment, but that's like basically intimidating you on the basis of sex. Requests for sexual favors. Hey, I'll give you the raise if you have sex with me or go out on a date with me. That's a form of sexual harassment. Sexual comments, jokes, emails. So if sending emails that have sexual content in them, that would be considered sexual harassment. Showing photos that are sexual in nature in the workplace or in educational environment, that would be considered an example of sexual harassment as well. So when we're talking about the difference between sexual assault and sexual harassment, one thing to keep in mind is that sexual assault is a crime. That if you engage in sexual assault, you have engaged in a criminal or a prohibited offense. And as such, it's codified in criminal law. So if you want to know what constitutes sexual assault, that's outlined in state statute. In the next lecture, you're going to see that, that for quite some period of time in U.S. history, sexual assault was, it wasn't codified in criminal law. It was based on common law. So it was based on the decisions that judges had made in the past, and they would apply that to a present situation. And that changes in the 1960s, in large part due to feminists bringing sexual assault onto and identifying it as a problem. That now we have, all states have codified into their state statutes what behaviors constitute criminal sexual assault. And so Wisconsin's statute is 940.225, and it shows the 4 degrees of sexual assault that are present in Wisconsin state law. So bottom line is sexual assault is a crime. What that means is, and this will be familiar to those of you who are also in my criminal justice class, I know I have some overlap, is that, a crime is the state versus the individual. And so that when you engage in a crime, it's basically an offense against the state. The state of Wisconsin, in this instance, has said that if you engage in this act, you've committed a crime. If you engage in the act, then the state has an obligation to charge you with a crime. And so it would be Wisconsin versus name of the criminally accused. Okay, so it's state versus individual. And that when you are charged with sexual assault, then you might plead guilty to that charge, which many people do. I mean, for all criminal cases, most cases people do not go to trial, but they plead guilty. Or if you do not plead guilty and you plead not guilty, then there would be a trial with a jury or in front of a judge, just like any other criminal or endeavor. And so, that the individual would either be acquitted, found to be not guilty, or they would be found to be guilty. The evidentiary standard, again, for those of you in my crime class, this is going to be familiar, but to be found guilty of a crime was a pretty high bar. And so the burden of the proof is on the state, and they have to prove beyond a reasonable doubt that this individual is guilty of the crime that they've been charged with. And if you're found guilty or plead guilty, you get a criminal penalty. And so that criminal penalty can be something like probation, or it could be home confinement, or it could be significant incarceration if you're found guilty of a higher degree of sexual assault. So, for example, in Wisconsin, I'm sorry if you're hearing my cat meow in the background, it must be dinner time. In Wisconsin, if you're found guilty of first-degree sexual assault, it's a significant penalty. You can receive up to 60 years in prison. So sexual harassment is not a crime. If you engage in sexual harassment, you haven't engaged in a crime, but instead you've engaged in a civil offense. And sexual harassment, the behavior of sexual harassment is illegal. It's just not a criminal, it's not a criminal offense. It's a civil offense. It's illegal because federal and state civil rights laws prohibit sexual harassment. So since sexual harassment is seen as a form of discrimination, sexual discrimination, Title VII in the Civil Rights Act of 1964 prohibits sexual discrimination in the workplace, and Title IX of the Education Act prohibits sexual discrimination in institutions of education. So it is illegal if you engage in sexual harassment, but you would not be charged with a crime if you engaged in the sexual harassment. However, that individual, the harasser, but usually more likely the institution, would be sued for violating civil law. So while it is possible for an individual who's been sexually harassed to sue another individual for sexual harassment, it's more likely that the individual is going to sue the institution that allowed that sexual harasser to work there or to go to school there. So let's take for instance, let's say you're a student at, the College of General Studies at Waukesha, and let's say, heaven forbid, there is some professor there that engages in sexual harassment. Well, we have Title IX officers. They're the ones who are charged with investigating incidences of sexual harassment. So as a student, you would report that professor and that behavior to the Title IX officer, and then they would investigate that incident. Now, let's say, and I doubt this would happen, but let's say the College of General Studies, UWM, did not investigate that sexual harassment and that professor was allowed to continue working. Well, you then would sue the institution for violation of civil rights law. And so that is, sort of the remedy, or that's the process that would take place to address this illegal behavior. Now, if a person is since when you're sued, you are not found guilty of a crime, but rather you are found to be the responsible party. And so that if you were to sue UWM for violation of civil rights law for sexual discrimination, that would be heard. It could go to court. Now, it could settle outside of court, but it could go to court. Jury would listen to it, and then they would determine who was the responsible party. And if you're found to be the responsible party, and again, here the evidentiary standard in civil law is lower because the sanction for violating civil law is not as harsh as the sanction for violating criminal law. So the evidentiary standard is that when you look at all the evidence, it seems as if UWM was in fact responsible for allowing sexual harassment to take place. And there wouldn't be a criminal penalty. The University of UWM wouldn't go to jail, but rather they would have to pay a penalty. They would pay money to the person that was harmed by the sexual harassment for the damages that they experienced as a student being, sexually harassed and discriminated against in the classroom. Now, keep in mind that harassment can be coupled with sexual assault. So on the one hand, you could, sue an institution for allowing a sexual harasser to work there and for them not taking any action. But if that sexual harasser actually engages in sexual assault, so let's say the professor engaged in some unwelcomed or unwanted or non-consensual sexual contact, that's sexual assault. And so that, let's say somebody requests sexual favors from somebody else, that's sexual harassment, but then there's some non-consensual sexual contact, that's sexual assault. And so we do see that there is an overlapping between civil law of sexual harassment and criminal law of sexual assault. All right, that's it on this lecture. In the next lecture, we're going to be taking a look at the evolution of sexual assault policy in the United States, the evolution from it being treated as mostly a private matter to a fully public matter. So thanks for listening, and I'll talk to you again soon.